Recently, more than 30 Shiv Sena members of the Legislative Assembly in Maharashtra left for Surat. News reports suggested that, led by Maharashtra Cabinet Minister Eknath Shinde, these MLAs were eventually camped in Guwahati in Assam. As it so happened, both Gujarat and Assam are states ruled by the opposition Bharatiya Janata Party. As this rebel group inched towards two-thirds of Shiv Sena's strength in the Maharashtra Legislative Assembly, the threat of the Mahavikas Aghadi losing majority in the assembly became all too real.
Hello everyone. In the 7th episode of Vidhi's Legal Capsule, prompted by the political crisis unfolding in Maharashtra, Mayuri and I attempt to explain the fundamentals of the anti-defection law, the exceptions to this law, and what possibly lies ahead, particularly for this law. In India, political defection or floor crossing, horse trading, referred to by whichever name, means the conscious abandonment by a legislator of their duty and allegiance to their political party. So the shifting of allegiance by legislators influenced either by money or the lure of power has long dominated political corridors in India. In fact, many of us might actually recall how back in 1967, a certain MLA in Haryana switched parties thrice in a day, setting off the proverbial Aaya Ram Gaya Ram to refer to defections in India. A spate of political defections continued in the decades following the 1960s.
As political defections continued unabated, in 1985, the 52nd Amendment inserted the 10th schedule in the Constitution to address instances of frequent floor crossing by the legislators. The 10th schedule enshrines the constitutional provisions to curb political defections among elected members of a political party. The 10th schedule disqualifies an elected member in case they cross the floor in any one of these following circumstances. First, if a member of a house belonging to any political party voluntarily gives up the membership of that party, and if they vote in the house against such party's will. Second, if a member elected as an independent candidate joins any political party soon after the election. Third, if a nominated member of the House joins any political party after the expiry of 6 months from their nomination. Evidently, the 10th schedule makes provision for disqualification of individuals in case they are to defect to any one of these ways. Having said that, there are certain exceptions to the general law on anti-defection. Ritwika, what are these?
So originally, the anti-defection law contained two exceptions. First, in case if there was a split in a political party, and second, in case of mergers between parties. Now, the split provision exempted a member or members from disqualification from a political party if at least 1/3 of such members of that political party formed a separate group. As it turned out, there was excessive misuse of this provision by parties, many of whom engineered splits. And this exception was eventually omitted from the Constitution, omitted from the 10th schedule in 2004 by the 91st Amendment to the Constitution. So while the split exemption is now gone, the merger exemption still remains. When can political parties be said to have merged under the 10th schedule? Paragraph 4 of the 10th schedule, under which the merger exception is found, talks of two kinds of entities, and the audience should bear with us here for a minute. What are these two kinds of entities? First, the original political party, and second, the legislature party. Now, a legislature party means the group consisting of all elected members of a house for the time being belonging to one political party. So the key here is members in a house. The original political party means the political party to which a member belongs. And of course, an original political party will obviously also consist of members outside of the house. A bare reading of paragraph 4 suggests that the merger can take place only when an original political party merges with another political party, another original political party, and at least 2/3 of the members of the legislature party have agreed to this merger. So only if these two conditions are satisfied, the group of members which merge with another political party, basically the group constituting 2/3 or more members, cannot be disqualified on grounds of defection. They escape the wrath of the anti-defection law. Now, this is the consequence of the combined reading of the two subparagraphs that paragraph 4 has. But owing to its confusing language and confusing wording, paragraph 4 has exposed itself to multiple interpretations. What do these interpretations look like, Mayuri?
One plausible interpretation of the merger exception is what was mentioned just now, that a valid merger can take place only when one original political party merges with another political party. And this merger is supported by 2/3 of the legislature party. What would such a merger look like? Hypothetically, let's consider a legislative assembly where the National Democratic Alliance is in majority, comprising the BJP and let's say 3 of its allies. The Congress has the second largest share, and the rest of the seats are occupied by independents. For a valid merger between one of the BJP's allies in this case with, say, the Congress, first, the ally will have to merge with the Congress outside of the House. And then 2/3 of the elected members of the ally in the House will have to assent to such merger. However, there's another way in which paragraph 4 has been interpreted. This interpretation allows 2/3 of a legislature party to form a group and solely merge with another political party. And this is deemed to be a merger of one original political party with another. If we are to apply this interpretation to the current goings on in Maharashtra, this is how it would look like. Say the Shiv Sena has 55 MLAs in the current assembly. If 2/3 or more of Shiv Sena's MLAs are to form a group and merge with another political party, such group would have validly merged with them. They would, of course, then also escape disqualification. It is this interpretation of paragraph 4 that has found favor in many high courts in India. In fact, earlier this year, Goa bench of Bombay High Court dismissed a plea seeking disqualification of 10 Congress MLAs who crossed over to Bharatiya Janata Party, and it held it to be valid merger under paragraph 4 of the 10th schedule. This particular interpretation of merger provision has made defection easier, especially for smaller legislative assemblies, where it is possible for even a sole member to constitute 2/3 majority and cross the floor without getting disqualified.
Now, this might sound like a lot of legalese for our audience, so I would like to take them for a trip down memory lane. It is very interesting to note that in 1985, when the anti-defection law was being discussed in Parliament, George Gilbert Swell, who was a former parliamentarian from Meghalaya, expressed this exact concern. He alluded to the future of the smaller regional parties while discussing the merger provision. In fact, he wondered as to what would happen to these parties if elected members in the House belonging to them were to merge with another political party. Because by doing so, they would have abandoned the organizational machinery of their original political party. However, they would still not attract disqualification, because smaller the strength of a legislature party, easier it would be to muster numbers for a valid merger. As it so happens, this is precisely what the merger provision has led to in practice. Now, coming back to the present day, and irrespective of the size of legislative assemblies, the exemption given to mergers belies the purpose and intent of the 10th schedule. In fact, the merger provision can very well be labeled as a possible cause for the 10th schedule's questionable success rate. And much like the split exemption, the merger provision is currently being excessively misused to engineer group defection. In fact, some of the recent instances that come to mind are when in 2021, 12 out of 17 Congress MLAs in the Meghalaya Legislative Assembly joined the All India Trinamool Congress. In 2017, the Indian National Congress finished as the single largest party in Goa with 17 seats. But by 2019, as many as 10 Congress MLAs crossed over to the BJP, reducing the Congress to a minority. Of late, other states such as Rajasthan, Madhya Pradesh, and Karnataka have witnessed similar instances, possibly and sadly. The list could go on. In some of these cases, such as in Meghalaya and Goa, the speaker, who is the deciding authority under the 10th schedule, did not disqualify the rebelling MLAs.
So this brings us to certain other concerns, some of them procedural, about enforcing the 10th schedule. A defection petition is decided by the presiding officer of the House, the Speaker in case of Lok Sabha and Legislative Assembly, and the chairperson for Rajya Sabha or Legislative Council. But let's not forget that the Speaker sits in a paradoxical position. She belongs to a particular political party, but is required by the Constitution and its convention to conduct the proceedings of the House in a neutral manner. Thus, the speakers are often torn between parliamentary duties and party loyalties. Further, the 10th schedule also does not lay down a strict timeline within which a defection petition is to be decided by the presiding officer. The Supreme Court in 2020, in Kesham Menguchandra Singh versus the Honorable Speaker Manipur, observed that a petition urging the disqualification of a legislator on the ground of defection must be decided within 3 months. However, this time frame suggested by the Supreme Court is only indicative. No wonder then that defection petitions lie pending before the presiding officer for years, while the allegedly defecting members enjoy the full term of their membership of the House. Also, as a matter of practice, these petitions are not carried beyond the expiry of the term of this House to a newly constituted House. Effectively, that means that the legislator gets a complete acquittal from all allegations of defection.
So where do we go from here? The situation definitely seems quite grim. Because despite the existence of an anti-defection law, or perhaps because of it, the Constitution has remained unable to arrest defections. The Vice President of India, Mr. M. Venkaiah Naidu, mentioned a few months ago that the anti-defection law allows wholesale defection, but not retail defection. It might sound funny and amusing, but it is rather unfortunate that the law currently carries the dubious distinction of fueling the problem it was meant to remedy. So while wholesale deletion of the anti-defection law has been mooted, till that happens, few high priority amendments must be brought about to make the law workable in a parliamentary democracy. What can these amendments look like? So to begin with, just like the provision on split, the merger provision as it presently exists must definitely go. Defection, whether by an individual or by a group, is definitely supposed to be punished. The provision in its current form suffers from convoluted drafting and is being misused to destabilize governments. We've seen far too many examples of that happening. The Supreme Court has expressed interest in academically reviewing the 10th schedule for future guidance. So this academic revisit of the 10th schedule, one that accounts for both party discipline as well as the freedom of speech of party members, should happen soon.
On the issue of who decides disqualification petition, perhaps older policy recommendations could be revisited, given how presiding officers may be bound by their party affiliations. An independent authority could take over the job of deciding cases of disqualifications that are triggered by defection. Recommendations dating back to 1990s and 2000s have merged the possibility of Election Commission of India or the president or the governor who work on the recommendation of the ECI in these cases, becoming the deciding authority. Irrespective of who the deciding authority is or would be, strict timelines must be set for deciding defection petitions in the House. So none of these suggested reforms will happen very soon. In fact, no amendment should be made to anti-defection law abruptly or without adequate thought. For the preservation of Indian democracy and its representative institutions, it is essential that incremental but meaningful reforms are brought about in the anti-defection law.
Thank you very much, everyone, for tuning in. We hope you found this episode of Vidhi's Legal Capsule interesting and useful. Please join us next time for more such legal capsules. Thank you.